Allow me to introduce Advocate Shivam Tyagi, a distinguished speaker for our Sports Law in India course. Advocating at the Delhi Bar Council, Mr. Tyagi is a legal luminary with a wealth of experience. He holds a dual degree in Bachelor of Laws, BA LLB from Symbiosis School, Pune, Symbiosis International University. Mr. Tyagi is the managing partner of the renowned law firm Chambers of Shivam Tyagi and Jatin Julka, with a presence in Delhi, Jaipur, Lucknow, and Bangalore. His legal expertise spans across diverse sectors, including representing industrial development authorities, real estate developers, and Telematics Association of India, among others, at various judicial forums. Notably, he serves as an empaneled counsel for the Small Farmers Agribusiness, a society promoted by the Department of Agriculture and Farmers Welfare, Ministry of Agriculture and Farmers Welfare, Government of India. His involvement in the Rights Protection Program as a spotter for the International Cricket Council during the ICC World Cup 2020 in 2016 at Arun Jaitley Stadium is a testament to his commitment to the field. In this role, Mr. Tyagi played a pivotal part in identifying and reporting sponsor rights violations, contributing to the effective execution of in-stadium anti-ambush marketing and trademark protection initiatives on behalf of the ICC. We are honored to have Mr. Shivam Tyagi as a speaker. We look forward to his insights on sports regulation and governance in India. His vast legal knowledge and practical experience, I hope, will undoubtedly enrich our course. Thank you so much for being here, Mr. Shivam Tyagi. Over to you.
Well, thank you, Mr. Subramaniam, for the warm welcome. Good evening, everyone. It is indeed my pleasure and honor to be here. As you all know, sports form an important part of human resource development. In our country, history of sports can be traced back to the Mahabharata, which narrates an instance where the game of Chaturanga, modern day chess, was played between the Pandavas and the Kauravas. Traditionally, the sporting activities were known to be private social activities and separate from the reach of legal framework. However, in the recent years, particularly in the 20th and the 21st century, the sports and games have moved beyond physical development of human body and entertainment and now have acquired a form of profession and culminated into large scale business involving numerous stakeholders. Presently, there are two broad aspects of every sport. A, the rules of the game, and the commercial aspects of the respective sports body organizing the sport. Yeah, in this lecture today, we'll be covering all of these topics. The governance of sports. Sports has features that distinguish from other areas of organized human activities. These features are an important reason why sport is mostly self-governed through autonomous institution. So in the lecture today, we will understand why sports have adopted this approach. We will discuss how these autonomous institutions have tried to meet the standards of governance that they have been required to maintain. We shall discuss how the institutions, the governing bodies, the sports federations achieve these standards through different countries in which a sport may be practiced through a common governance structure. Lastly, and most importantly, we will look at the role of the Olympic movement and the Olympic Charter in pursuing these standards. So, mostly the governing bodies of sports are autonomous, not for profit organizations with amateur and voluntary administrators. Autonomy is a feature that we'll talk about again and again during this entire lecture, and it is strongly encouraged within the sporting world. The self-governance of sport by self-managed sports organization is a part of the fundamental principle of Olympism. Now, what is Olympism? It is the name and the guiding philosophy of the Olympic movement. The independence and autonomy of sports governing bodies is, in fact, a necessary condition for the recognition, say, by the International Olympic Committee under the Olympic Charter. Now, similar to the Olympic movement, members of Football Global Governing Body, FIFA, have also committed to manage their affairs independent of any third party. Now, this model is a part of the socio-cultural model where protection of sporting values takes priority over commercial and governmental interests. I'll give you an illustration. See, sometimes there arises a conflict between the governmental interest and the values of the sporting world. Apartheid policy in South Africa were in conflict with the sports interest in ensuring racism. Now, it is very imperative for us to understand the distinguished features of sports from other areas of organized human activity or any other economic activity as such. How is sports different from any other activity? Let us understand why autonomy from governments and commercial interest is such an important virtue for sport. Number one, the specificity. Most arguments for the independence of sports governance are premised on the specificity of sports. The argument goes that there are unique features found in sports market that are not found in any other market. It requires a very unique model of governance and management. Now let us look at the resolution 1608 of 2008 of the Parliamentary Assembly of the Council of Europe, which says sports undoubtedly has a specific nature that sets it apart from any other field of economic activity. A good example that illustrates the specific nature of sports is the fact that sport is an exception to the commonly held belief in other areas of economic activity that absence of competition between rivals is a sign of market failure in sports. In sports, unpredictability of outcomes is essential. The spectators, they won't watch the matches if the results become predictable. So unrestrained competition, which will theoretically result in the complete domination of one sporting entity by another, is not good for unpredictability in sports. Now, quite uniquely, therefore, every sporting entity is economically dependent on the well being of its rivals. So, this is why sports is not run along the market principles but governed using not for profit organizations. The national element now lends sport another curious set of features. The team representing nations compete in several marquee sports events, like the Ashes Test matches between England and Australia, or the World Cup of football, or the ongoing World Cup of cricket. Now, the obligations of private entities operating in sporting world, such as sports persons, sporting clubs, and the broadcasters towards nation and governments are repeatedly negotiated and are sometimes the subject of legal regulation. Such extensive obligations to nations and governments are not common features of other areas of economic activities. So, let's take a look at Article 165 of the Treaty on the Functioning of the European Union, which recognizes the specific nature of sports. Its structures based on voluntary activity and its social and educational function. The European Commission's white paper. So the European Commission's white paper on sports refers to the specificity of sporting activity and the specificity of the sports structure. It comprises of features such as separate competitions for men and women. We were discussing the European Commission's white paper on sports, which refers to the specificity of sporting activity and the specificity of the sport structure. It comprises of the features such as separate competitions for men and women, limitations on the number of participants in competitions, or the need to ensure uncertainty concerning outcomes, and to preserve a competitive balance between clubs taking part in the same competitions. There are other features as well, which includes the autonomy and the diversity of sports organizations, a pyramid structure of competitions from grassroots levels to the elite level, organized solidarity mechanisms between different levels and operators, the organization of sport on a national basis, and the principle of a single federation per sport. See, the governments are accountable to the citizens they govern over. The businesses are accountable to markets and the shareholders. The governing bodies of sports may not pursue profit and may want to remain autonomous from governments, but they are still accountable for their performance in the governance. Now, there comes a lot of responsibilities with autonomy. Say for athletes, it is often very difficult to pursue a sporting discipline professionally without the recognition from the relevant governing body. The sports governing bodies, therefore, exercise considerable influence over the right to pursue a livelihood. Further, many business entities, sponsors, and broadcasters, for example, may seek to participate in the sporting world, and they often require sanction from sports governing bodies to do so. The several significant economic rights, therefore, are at stake in the governance of modern sports. The sports governing bodies, therefore, occupy a position of responsibility with respect to these rights. For these reasons, the governance of sports needs to meet some standards, including the standards of fairness and transparency. Now, even the Olympic movement, for which the autonomy of governance of sport is an important guiding principle, has acknowledged the responsibility that comes with autonomy. The fifth fundamental principle of Olympism recognizes that sports organization within the Olympic movement shall have the rights and obligations of autonomy. As we have seen previously, however, because of the importance of autonomy, standards imports from outside the world of sports are usually not welcome. Instead, these bodies prefer to demonstrate strong internal constitutionalism, due process, and good governance. Now, over the years, the spectators, athletes, sponsors, and broadcasters have suffered because some governing bodies of sports did not meet these standards. As a result, the government has always felt the need to compel sports governing bodies to fulfill their responsibility through law. Now, such regulation has been viewed by suspicion by the sporting world as attempts to disrupt the autonomy of sport governing bodies. So, the 13th Olympic Congress has a great significance, which was held in Copenhagen in 2009. They developed a very nuanced understanding of autonomy and the relationship between sporting governance and general law. Among other things, it highlights that the autonomy of sport should be defined to reflect the principles of respect, responsibility, and reliability. It recommended that the respect for the enforcement of rules of good governance, equality, and fairness in sports and sports administration, as established by the Olympic movement and set out in the Olympic Charter, within the necessary and essential autonomy of the Olympic movement. It also urged the relationship between the Olympic movement and government to be based on respect for the applicable law. Now, para 41 of the recommendations of this Congress is an excellent statement of the responsibilities that accompany autonomous governance. Say the legitimacy and autonomy of the Olympic movement depends on upholding the highest standards of ethical behavior and good governance. All the members of the Olympic movement should adopt as their minimum standard the basic universal principles of good governance of the Olympic movement as proposed by the International Olympic Committee. Now, all the members of the Olympic movement must always demonstrate integrity, accountability, and transparency, as well as the highest level of management skills. And they must ensure that at all times their legal status is both fully consistent with their activities and responsibilities and wholly compliant with the laws of the land. We will learn more about the central role of the Olympic movement in guiding the governance of sport later in this lecture. See, in order to understand the regulations and the principles of good governance and specifically the governance in sports and regulations, it is very imperative for us to understand the distinguished and different features of sports in comparison to any other activity. So, other features of sports include the uniformity of rules and the common governance structure. And in order to understand these features, let's dive deep into some salient features of the international government governing bodies. So, see, Sporting disciplines have historically shown a tendency to consolidate so that they can benefit from uniformity across the globe and scale. The same or a very similar sport may be in existence in different parts of the globe, but they can come together by adopting a common governance structure and uniform set of rules under which the sport is played. Even different sports have seen the benefits of coming together under the umbrella of Olympic movement. Now, as a sporting discipline spreads across the globe, the local and national governing bodies of sports realize the benefits of cooperating among themselves and with an international governing body. The local governing bodies of a particular sporting discipline, which conducts and governs the sports locally, come together to form a governing body for a larger geographical area, such as a national federation for that sport. They do this by agreeing to adhere to a set of rules and principles. The same is seen in the international context. National federations of a particular sport, on the other hand, are happy to share in the commercial benefits and other opportunities that accompany the conduct of the sport on a global scale. Say, for the conduct of sports on a global scale, what are the requirements? See, it is important for all the constituents to agree upon a uniform set of rules and a common governance structure. It is also necessary for the institutions at all levels of governance to fulfill responsibilities that accompany their autonomy. This can only be achieved by securing universal respect for a set of documents, including the constitutional documents of the global governing body. Now, I'll give you an example. Say, any association which is responsible for organizing and supervising football in its country may become a member of FIFA. The leagues and other groups affiliated to a member are subordinate to the member concerned, but they need to be recognized by it. So AIFF, the All Indian Football Federation, has been a member of FIFA since 1948. The state level federations like Kerala Football Association, professional leagues like the I League, and the clubs like East Bengal, Mohun Bagan are subordinate to AIFF. AIFF is subordinate to FIFA. And all these have to be recognized by each other. I'll give you an example. Say, between 1975 and 2002 alone, more than 60 national associations were accepted as members of FIFA alone. See, I'll make you understand what are the mechanisms that goes behind. Say, when an association applies to the General Secretariat for admission as a member, it should submit its own statutes as well. Now, these statutes have to necessarily provide for compliance. For instance, with the FIFA statutes, FIFA's constitutional document, the regulations and the decisions of FIFA, the compliance with the laws of the game, and to recognize the role of the Court of Arbitration for Sport. The success of FIFA in securing compliance with these rules and principles is partly responsible for the global scale and the uniform manner in which professional football is played today. Guys, please refer to the next slide. World Athletics. Slide number 9, please. Yeah. The World Athletics was formerly known as the International Association of Athletics Federations. Now, the world governing bodies for athletics was founded to fulfill the need for a world governing authority, for a competitive program, for standardized technical equipment which are to be used, and for a list of official world records. Now, the World Athletic comprises of the national governing bodies for athletics, the compliance with the IAF constitution, the competition rules, the regulations are one of essential conditions for the membership in IAAF, which is now known as the World Athletics. Yeah. When National Association applies for membership, the submission made to the council should include a current copy of its constitution and bylaws and a formal undertaking to abide by the documents mentioned above. Slide number 10, please. Next slide. National Olympic Committee. The national level governing bodies of the Olympic movement, international sports federations, the global level governing bodies of various sports and their associations are essentially partners of the IOC, which is the International Olympic Committee, the global governing body for the Olympic movement. See, upon recognition by the IOC as national Olympic committees and the International Sports Federation, these body can attain certain rights to participate in the affairs of IOC and the Olympic movement. The compliance with the Olympic Charter is an essential part of the procedure for the IOC to recognize IFS and NOCs. Before recognizing a National Olympic Committee, the executive board of the International Olympic Committee has to approve its governing statute. Slide number 11, please refer to slide number 11. The waterfall of recognition. I've highlighted and given the example of FIFA, but all the governing bodies in the world, say for football or the International Olympic committees, they have an upper level of governance in the sporting world, which receives legitimacy from recognition of its authority by several bodies at lower levels of governance. A body working at a lower level of governance, on the other hand, derives legitimacy from its recognition as a governing body by a superior governing body, such as the national or the governing body. So there is a network of agreements between larger and smaller governing bodies holding together the framework that is used to conduct and govern the professional sport. The term waterfall of recognition is sometimes described to the term waterfall of recognition is sometimes used to describe this sort of an arrangement. Slide number 12, please. Now, another distinguished feature of sports, setting standards for all level of governance. The agreement between the National Federation for a sport and the International Federation is of a constitutional nature. See, it creates and places rights and obligations, not just on the two parties to the agreement, but also on all the entities involved, say the athletes, the clubs, and other entities that agree separately to abide by the agreement. Importantly, they also create obligations on institutions at all levels of governance to meet certain standards of governance. These agreements even contain methods to enforce some of these obligations. Say, for instance, an international governing body of a sport may withdraw its recognition of a national governing body or suspend its membership if it does not meet its obligations. Therefore, institutions at the lower level of governance have been bound to the standards set in the constitutional documents of various sports once their primacy is accepted. Now, these agreements can also be said to constitute the private law of sport because it establishes the rights and obligations between private individuals. The rights and obligations created by this network of agreements can be forced through courts of law using law of contracts. Kindly refer to the next slide. Let's discuss about the status of the Olympic Charter and its importance. Say, in this private law of sport, the Olympic Charter has a superior position. See, almost all the governing bodies in the sporting world are bound to it by the relationship of mutual recognition between different national level governing bodies of the Olympic movement, global level governing bodies of different sports, and the International Olympic Committee. The sporting world has even been able to take forward some of its important interests, such as securing the participation of the various constituents of the sporting world in the World Anti-Doping Program, fighting racism in sport, and also encouraging the resolution of disputes before the Court of Arbitration for Sport, which is forwarded through the Olympic Charter. Next slide, please. So I'd like to conclude by saying that we have seen that a sport needs to set its own standards of governance. We've learned about the private law of sport, how it has been used to set and enforce these standards. See, the waterfall of recognition between institutes at different level of governance is usually the part of the private law of sport, and has been used to meet those standards at all levels of governance and to achieve a common governance structure. See, sometimes, however, the law of the land steps in to set standards from outside point. The tussle between the sports to remain internally governed and the urge of the law of the land to hold sports organizations accountable will be a constant theme in our study of sports and the law. Slide number 14. Now, let us understand why the governments have an interest in the sporting activities, and all these sporting federations are governed on autonomy. So, let's understand this complex relationship between the government and the sporting federations. So, let us understand some practical implications of the conflict between autonomy of governance in sport and the interest of governance in regulating sport. To understand all of this better, we will look at why governments are interested in the governance of sports and the competence of the union executive to legislate on the subject of sports. As we learned previously, the autonomy of government is a prized virtue in sport. Self-regulated and self-managed governing bodies of sports are among the fundamental principles of the Olympic movement, and the autonomy of sports organizations is a necessary condition, as we've discussed this again and again. So, the autonomy of sports organization is a necessary condition for the recognition by IOC under the Olympic Charter. Sports therefore needs to set its own standards of governance. This has been done using the private law sports, which comprises the network of agreements between the governing bodies at different levels. We also saw, however, the governments often have an interest in setting standards from outside the world of sports through law. Now let us look at the reasons why government would want to do so. So the government interest in sporting activities. Hey, I'll try to give as many illustrations as I can. Now why are the governments interested in the sporting activities? Public health. See, recreational participation in sports is generally considered a vital element of a healthy lifestyle. This has apparently great significance for public health. Now, in 2003, Canada passed the Physical Activity and Sports Act to encourage, promote, and develop physical activity and sport in Canada. In 2009, India's Ministry of Youth Affairs and Sports, also known as the Sports Ministry, launched the National Playing Fields Association of India after there were concerns about the shortage of playing fields in India. Now there is a great deal of economic development involved, so why wouldn't the government be? So the sport is a part of the economy and its growth can contribute to the growth of the overall economy by spurring demand for ancillary goods and services such as the sports equipment, sports coaching, sports medicine, and sport arenas. So in 2008-9, the Sports Ministry launched the Panchayat Yuva Krida or Khel Abhiyan. This was a centrally sponsored scheme to develop basic sports infrastructure in village and block panchayats and to hold district level competitions. Next slide, please, slide number 15. Patriotism and national identity. See, thirdly, sport is linked to ideas of patriotism and national identity. The governments are concerned about the performance of national teams at international competitions and compete amongst each other to successfully host global sporting spectacles. For the same reason, governments have often used sports for geopolitical jostling and diplomacy as well. Now let's look at an illustration. See, prior to the 2012 Olympics in London, the government of the state of Haryana announced a cash reward of 2.5 crore to all athletes from the state who managed to win a gold medal at the London Olympics. Now, Mr. Adolf Hitler viewed the 1936 Olympics in Berlin as a way to promote his Nazi government and his ideas of racial supremacy. It was only other countries, it was only after other countries threatened to boycott that Jews and blacks were permitted to participate. Other illustrations like, see, even we've discussed the South African apartheid policy, but it is relevant here. See, South Africa under the apartheid system, which was a system of racial segregation that prevailed in the country and which faced a variety of international boycotts, including sporting boycotts. The United Nations compiled an informal list of sportspersons and officials who participated in events in South Africa to put moral pressure on athletes to not tour the country. Next slide, please. See, since sport is a very visible area of human activity, many issues that may exist beyond sports are amplified through it. Therefore, governments have a compelling interest in stamping out these problems. It is important to enthusiastically tackle them in sport. I'll share an illustration. In Jan 2013, the Department of Italian Interior Ministry announced that the public security officials would be empowered to stop football matches in case of racist behavior by spectators. Now, this kind of behavior has also been recently observed in United Kingdom. In May 2010, the French government disbanded 7 fans associations in an attempt to eradicate hooliganism surrounding football. Now, fifth and most importantly, since governing bodies have a virtual monopoly over the conduct of the sport they govern, there is usually no market pressure on them to reform, innovate, or even be efficient. Therefore, governments may need to intervene to protect the livelihoods of the professionals. Sometimes the intangible investments made by fans and the commercial interests of sports and broadcasters. Now let's look at this illustration. In July 2011, the Culture, Media and Sports Select Committee of the Parliament of the United Kingdom published a report that recommended a fundamental reform of the Football Association, which is the governing body for football in England. The report felt that a change was essential to address financial instability and the levels of debt in the game and to secure its future. Even though this report is not binding on the FA, the recommendations are an important step in improving the governance of football in England. Even India's Union Executive has over years, acting through the Sports Ministry, issued guidelines to all sports governing bodies in India, among other things, that these guidelines have aimed at ensuring that overage players are not allowed to participate in the national and other championships and capping the tenure of office bearers at the and the national 14 sports federations and at the International Indian Olympic Association. Can I have the next slide? Slide number 17. The regulation of sports in India. Now, who has the competence to regulate sport in the Indian constitutional scheme? Who can make law on the subject of sports in India? The answer to this question has to begin with an examination of the seventh schedule of the Constitution of India. See, the seventh schedule contains three lists: List 1, List 2, List 3, known as the Union List, the State List, and the Concurrent List, respectively. Under Article 245 of the Constitution, the Parliament of India alone is competent to make laws on the subjects mentioned in the Union List. Both the Parliament and the legislatures of the state are competent to make laws on the subjects mentioned in the concurrent list. The state legislatures alone are competent to make laws on the subjects mentioned in the state list. Under Article 248 of the Constitution, the Parliament has residuary powers to make laws on subjects that are not mentioned in the state list or the concurrent list. Now, please look at slide number 18. So, entry 33 of the state list, which is the list 2, reads theatres and dramatic performances, cinemas subject to the provisions of entry 60 of list 1, sports, entertainment, and amusements. So, apart from entry 33 of the state list, sports does not find any mention in any of these three lists. State legislatures, therefore, by this logic, can make laws on the subject of sport. However, we must not forget that the legislatures of states can only make laws that apply within the territorial limits of their respective states. Therefore, they are not capable of making laws on subjects such as interstate sports competitions and international sports competitions. So, as a consequence, under Article 248 of the Constitution, the Parliament can make laws on these subjects. The Delhi High Court accepted this as a position of law in a 2009 case. In addition, the Delhi High Court located the source of Parliament's power to legislate on the subject of sport in a liberal interpretation of the term education that appears in entry 25 of the concurrent list. The executive lawmaking. At the same time, we should remember that the Parliament is not the only source of law. The Union Executive, that is the Prime Minister and his Council of Ministers, can also make law. Article 73 of the Constitution, which describes the scope of the executive power of the Union, allows the Union Executive to make laws on subjects that the Parliament has power to make laws on. Can I have the next slide? Kindly take a look at the slide number 19.
Mr. Shivam, one of the participants wanted to know the name of the case that you were referring to.
I'll certainly share the name of the case post this lecture. Yeah.
Oh,
Thanks. So the reality is that in India, the Parliament of India has not made any law on the subject of sports. And we will now learn the Government of India has tried to regulate national sport federations and the Indian Olympic Association through guidelines issued by the Sports Ministry. So kindly remember, basically on the subject of sports, therefore, the source of the executive powers to make law is the residuary power of the Parliament to make law of sport under Article 248, read with the description of the Union's executive power contained in Article 73. Now let's take a look at the next slide, the organizational structure of sports in India. So what is the current sports model in India? The existing model of governance of sports in India has primarily two wings. One in which the governing body are controlled by the Ministry of Youth Affairs and Sports. This wing has institutions like Sports Authority of India and other institutions working towards promoting sports training under Sports Authority of India. The other wing has the Indian Olympic Association, the State Olympic Associations, and the national and state sports federations, which all come under the IOA. However, the Ministry of Youth Affairs and Sports provides financial and infrastructural support to the national and state sports federations and indirectly control these federations through political representations. In accordance with the Olympic Charter, which restricts the governmental influence of sports federation, the sports bodies in India are autonomous bodies, while the IOA is the umbrella body under which the the state sports federations and they conduct various sporting events in the country. The government bodies operate under Ministry of Sports, playing a supporting role such as training and infrastructure management. Can we have the next slide, please? Now, in addition to all of this, there are federations for non-Olympic sports, such as the BCCI, the Board of Control for Cricket in India. These federations are directly affiliated to their respective international boards. Now, similar to the Olympic Charter, government intervention is restricted by the charter of their respective federations. The majority of these sporting bodies are registered as societies under the Societies Registration Act of 1860. These bodies are recipients of government aid in multiple forms, ranging from direct financial assistance to indirect tax subsidies in the form of tax benefits, especially in the case of BCCI. Now, in order to receive direct financial aid, a body is supposed to have a government appointed observer who oversees the internal process, such as utilization of funds, etc. Almost all the sports federations have eminent politicians, or retired bureaucrats elected as their office bearers, with the anticipation of utilizing their political power in various matters. Now, basically, the annual and the special general meetings held by the IOA decide on various aspects of sports in India. The voting rights in these meetings are given to the members as well as to the national federations for indigenous games in India. Also, Olympic associations at the state and the union territory levels, members of the IOC, as well as the representatives from Athletics Commission, have the right to vote in these meetings. Now, you'll be shocked to know out of the 72 national federations and state associations, I'll repeat it again. Out of the 72 national federations and state Olympic associations, 38 had presidents who were politicians in 2011-2012. Now, this is a process which is an old trend that has continued for decades. Political representation should have made these federations more accountable and open to challenges and replacements to the leaderships over time. Since this is not happening, it appears that most of these federations have been reduced to political mafias. This has a decisive effect on a lot of factors, including the composition of teams in a sporting event. The incentive for sports, the incentive for most of the politicians seem to be the publicity that they receive from sports in major events held across the country and even outside. Now, kindly take a look at slide number 20 through 23. We shall discuss the timeline of sports development policy in India. Hmm. We cannot discuss all these regulations, but we'll primarily be focusing on the national sports policy. So the National Sports Policy 1984 was formulated with the objective of raising standards of sport in India. However, the policy could not achieve its desired objectives. Therefore, it was reformulated with incorporation of specific welfare measures for promoting sports. Now, the National Sports Policy amendments in 2001, they came into existence with the aim of achieving excellence by way of coordination among the sport federations and ensuring the educational institutions, that is schools, colleges, universities in both urban and rural areas, provide facilities for sporting activities. Now, one of the aims of the policy was to pursue inclusion of sports in the concurrent list of the Indian Constitution and introduction of appropriate legislation for guiding all matters involving national and interstate jurisdiction. However, neither of these have seen the light of the day. Slide number 25, please. Say, after the sports policy was notified in 2001, the central government since then has revised and issued subsequent guidelines from time to time for assisting the sports federations. Even though the sports bodies are registered in different states under Societies Registration Act or even the Companies Act, their authority to function as sports federations is dependent on complying with the governmental guidelines. Next slide, please. Slide number 26. Yeah, just a moment. The government has taken several steps to improve the management and administration of sports by way of issuing numerous executive orders, circulars, and notifications, such as the notification of the Anti-Doping Code, the annual recognition of sports federation to ensure transparency and accountability, the enforcement of age and tenure limit in respect of office bearers of Indian Olympic Associations and the national sports federations. They've also brought the national sports federations under the purview of Right to Information Act. Measures to ensure free, fair and transparency of elections by the National Sports Federation. There have been measures undertaken to combat age fraud in sports and guidelines for the prevention of sexual harassment of women in sports. Slide 27, please. See, eventually, the stated aims and objectives of the sports policy, the guiding principles, as well as the old and new executive orders, circulars, and notifications issued by the government from time to time, they were compiled, merged, and culminated into National Sports Development Code of India 2011, which is also known as the National Sports Code. The guidelines enumerated in the National Sports Code have a threefold objective. A. To define the areas of responsibility of the agencies involved in the promotion and development of sports. B. To identify national sports federations eligible for coverage under these guidelines and set out in detail the procedures to be followed by the federations. C. The state eligibility criteria which the sports federations have to fulfill for availing sponsorships, grants, and other forms of assistance from the government. Slide 28, please. Let us revisit the sports policy of 2001, which laid down a set of principles. Now, these principles have been incorporated in the National Sports Code 2011, and these are read as under. See, there was a clear demarcation for the role between the National Sports Federation, Sports Authority of India, and the government. The grouping of sports disciplines into priority, general, and others for the purpose of determining the entitlement for government assistance. C. Provision made for the annual sanctioned budgets of development plans. D. Binding tripartite agreements between national sports federations, the departments, and the state authorities of India. Sports Authority of India, sorry. Next slide, please. Slide number 29. E. There was an emphasis on professionalizing and upgrading the administrative and financial management of federations. F. Emphasis on systems to handle player grievance. The appointment of registered CAs to ensure proper maintenance and transparency of accounts. And lastly, the recognition of the role of sports promoters, particularly in event management. Now let us look at slide number 30. See, over the years, many sports governing bodies have come up in respect of various sport disciplines: athletics, cricket, hockey, football, basketball, badminton, Paralympics, wrestling, volleyball, etc. The government of India has been actively supporting these federations towards achieving their objectives. Promoting sports is the responsibility of national sport federations, which are autonomous bodies, as you discussed, and the role of ministry to issue guidelines and notifications from time to time for the purpose of regulation of sports federations. Now, in light of this, let us also understand the roles and responsibilities of the National Sport Federations, Sports Authority of India, and the Sports Ministry. The national sport federations are responsible and accountable for the overall administration, management, direction, control, promotion, development, and sponsorship of the respective sport for which they are recognized by the government or the concerned international federation. They are expected to discharge their liabilities in consonance with the principles laid down in the Olympic Charter. or the charter of the Indian Olympic Association or the relevant international federation, as the case may be, and at the same time also compliant with the government guidelines applicable to the sports federation. The Sports Authority of India, sorry, the Sports Authority of India was established to fulfill the requirement of an apex body for coordinating various sports activities in India. The Sports Authority of India shall provide support, infrastructure, equipment to the national sports federations for identification, training, and coaching of sports persons, as well as other forms of assistance, which may include the release of funds to national sports federations in respect of proposals approved by the government. The role of ministry is also to determine the eligibility criteria for recognition of the sports federations and the quantum of assistance to national sports federations and other sporting bodies. Next slide, please. The national sports federations have been conferred with the recognition by the union government. They also enjoy various facilities and concessions provided by the government. However, if these sports federations do not comply with the government guidelines, which are issued from time to time, there is a strong likelihood to result in one or more of the following consequences for the sports federations. They may be barred from selecting national teams and represent India in any international event or forum. They can also be disallowed to use the word India in its name because inclusion of the word India suggests the patronage of the government of India. Loss of all India character and disqualification from regulating and controlling the concerned sports discipline in India. No rights to avail custom duty and income tax exemptions under the relevant provisions of tax law. They may also lose their rights to avail itself of the special dispensation to remit funds towards sponsorship, prize money, or activities abroad. No government jobs under sports quota for sportsperson who participate in events organized by the National Sports Federation that is not recognized by the government. They may also lose their admission for sportsperson of unrecognized national sports federations under sports quota in schools and colleges. Lastly, they may also lose the railway concessions to sportsperson participating in national championships organized by National Sports Federation that is recognized by the government. See, in any case, it is useful to remember that the understanding of autonomy in the Olympic movement, which became nuanced. Yeah. So this was the end of the presentation.
I'd like to extend my sincere thanks to Advocate Shivam Tyagi. Despite several difficulties that we were facing, you were very patient enough to keep the session going. So thank you so much. You had given a very comprehensive understanding of the entire sports regulation and governance that it's related issues that we are facing in our country. So thank you so much for being here, sir, despite your busy schedule. So participants, if you have any questions, you can post it on the chat box or you can unmute yourself and ask.
Yeah. And I'll be more than happy to take calls as well.
Oh, only one question, Mr. Shivam. Can you just answer? Only one.
Yes, please, Mr. Lennon.
Yeah. See, the if you spoke about this sports code, especially if you look at it, the autonomy of these national federations, even including the IOA, went to in 2014 they went to High Court, Delhi High Court, and then
Correct.
the court has very categorically said that if you want to be in India, especially in the IOA versus Union of India matter, said
Correct.
very categorically that you must follow the sports code of India, and they had to remove most of their clauses which were against the sports code. And then yes, Nitya case also it happened. And then if you see the Football Federation versus Rahul Mehra, there also the government interference came. Then in that Kabaddi, KP Rao versus Union of India, in that matter also if you look at it, mostly the sports code was, we don't know whether it is enforced or the government was trying to take away the autonomy, because as you said that it was mostly governed by people who had a political and social influence, who controlled the federations. But recent days that things are changing. Now, is it a healthy environment? Because sports code, yes, of course, it requires for many multiple
Mr.
reasons. Because you,
sorry to interrupt.
Yeah.
Could you please keep your question brief, because
the question
Mr.
is,
Shivam would like
does
to
it,
take the
does
lead.
it, does the sports code create a healthy environment, or does it going to go against the very spirit of the sport?
See, we have a long way to go when it comes to the right regulations pertaining to the sports. And see, again, majority of the national sports federations, they have managed to find out loopholes in order to avoid a perfect, near to perfect sports code. We are far away from, say, excellent question, Mr. Lennon, though. Mr. Lennon, I'll be more than happy to take it personally over a call,
Yes.
say today at 9 itself, if that's all right.
Yes.
Yeah.
All right.
Yeah, fine, no issue, please.
So,
Thank you again, Mr. Subramaniam.
yeah, thank you so much, Mr. Happy to introduce to you Dr. Anand Raut, an esteemed member of our faculty at MNLU Mumbai, who will be leading the module on online sports gaming landscape as part of our Sports Law in India certificate course. Dr. Raut serves as an assistant professor of law and holds the honor of being one of the founding faculty members of MNLU Mumbai. In addition to his role as a legal educator, Dr. Raut also carries the responsibility of the Deputy Director at the Center for Information Communication and Technology Law at MNLU Mumbai. He is further recognized as the Nodal Officer for the Pro Bono Club established in collaboration with the Department of Justice. Dr. Raut's diverse expertise and dedicated contributions to the field of law make him a valuable asset to our course. We eagerly anticipate his insights and guidance in the realm of online sports gaming. We look forward to an enriching session with Dr. Anand Raut as he shares his knowledge and experience with our course participants. Over to you, Professor.
Okay, thank you, Subramaniam. Thank you for that generous introduction. Okay, so first of all, I wanted to understand the background of the participants. Are they law students, or how is it? Or are they from law?
So, predominantly, we have law students. Apart from that, we also have advocates and teaching faculties of law and a few other divisions as well.
Okay, thank you. So I'll directly indulge into the topic as I understand. And what I'll do is instead of scrolling the PPT, I'll write in chat. Okay. Fine. So I understand that the topic given to me is online gaming, and not gambling, because these days the concerns that are raised with respect to online gaming, or what we more often read in news, is about gambling. Yes, some time back we also heard about online games being taxed, and there was a lot of hue and cry, the percentage at which they were taxed, and how it was not so beneficial for the online gaming sector. And well, there were uh, arguments that this might kill the online gaming sector. But but let me clarify that gambling I guess gambling would be dealt in a different session. So I will not plunge into online gambling and happening through gaming. So gaming games can be, of course, a game of skill, and it can be a game of chance. Money may be involved, may not be involved, but if it is a game of chance, money is involved, then those arguments of it being wager or that they are gambling, those arguments come in. So we are today going to focus about online gaming. And by online gaming, what do we mean is, and the way, generic in general sense, they are understood. Online game is a video game that is either partially or primarily played through the internet or any other computer network available. So this is a generic definition of an online game. It's a video game that is either partially or primarily played through the internet or any other computer network available. In law, online game means a game that is offered on internet and is accessible by a user through a computer resource or an intermediary. So this is how we this year 2023 we defined online games. Now the question is, where did we define it? Now we have Information Technology Act. Under that act, there is something called as Section 79 that regulates intermediaries, and IT Act has given powers to central government to for the proper and the effective implementation of the act. Central government can frame certain rules and regulations. So with deriving power from those provisions which allow them to do so, they enacted intermediary guidelines back in 2011, which was silent on online games. Then they moved an amendment in 2018, and finally what we see today in 2021 is the version of final version of intermediary guidelines. And in 2023 they also included online gaming intermediaries. Now we will see what all different types of gaming intermediaries they involved there, what is an intermediary, etc. Now online gaming has to be understood from two perspectives, from the player's perspective and from the industry's perspective. Of course there are other people also. Yeah, where was I was on the point of online games, wherein we discussed that online games have for the first time being discussed in the intermediary guidelines of 2023. Intermediate guidelines of 2021, the amendment got moved in 2023. We always look online games when we are very skeptical when we think about them, but they are playing a very significant role, and they need not always be perceived in a negative notion. Online games, through various studies, have been identified, recognized as a mode or medium of providing enjoyment. It has helped in building skills pertaining to teamwork, collaboration, imaginative adventure for children. Rather, there have been studies which says that it has played a healthy role and have contributed in the essential part of children's development and socialization. Now, so it need not be always looked from a negative perspective. Online games can also be looked from a positive perspective. But when I say children, we have to be, there are many issues that come up. So we will touch upon those issues later on. But before that, we need to understand how these online games have developed and what their nature has been. So, the nature of online games, uh, if you have to divide, it is either player versus environment or player versus player. That is the two modes in which the game is played. And let me add you here that the content is being studied, the online gaming content is being studied, and the gamers interactions in virtual societies are also being studied as a matter of study, because they are being considered as a social phenomena. And there is a different culture altogether that has grown in online games. So certain kind of slangs, certain kinds of practices, certain culture, so they have developed their own culture when these users they play online. So if the phenomenon of online game is to be, I know that we would be discussing here more of laws perspective. But if we have to regulate online gaming, we need not talk only from laws perspective. Norms of people, ethics of people, what do they believe in? Secondly, the market, you know, that is all economics of the gaming, the demand, the supply, then what all is available, what all is accessible, at what cost. That is market dynamics. What type of games are preferred by people. That market also controls the way online gaming takes place anywhere. Thirdly, of course, the law is there, and fourthly is the architecture. That means in what way these games are their programs are wrote, what is that they offer, because online gaming can open up a can of worms. It is sometimes a Pandora's box. You never know what can come out of it. Okay, so there have been instances of harassment, there has been instances of virtual grouping, there have been instances of uh, doing certain activities while playing online games which the object of the game did not allow. Now here what do we have to understand is every game has an object. Okay, so if there is a game where you are dressing up, or it's an online, or if it's a grooming game, okay, you do not expect your avatars getting killed over there, you do not expect someone stalking over there. Now such kind of things can cause some kind of shock to the players who are playing, especially when these games are in the nature of artificial reality or virtual reality, because because these games then become so realistic that the person who is playing them, or she feels that it is real, and no more than they assume just being virtual or online, but the consequences, the way in which they are perceived, it is real. Of course, there are certain games which the object of which is to kill people. Violence is the object. There you cannot come up with this argument that I never expected some such things happening to my avatar. But there have been games, social games. For example, there have been instances wherein games which were kind of multimedia platform, where the avatars get dressed up, something like that. And those games were hacked, and certain acts were committed on such avatars. So the question was, and because of that, certain people had to undergo certain amount of stress. They were in shock. What happened with their avatars? Naturally, there came an argument that they were just an avatar and they were not real persons. So you cannot say that something really bad happened to them, or you could say that, oh, they could have simply taken out their VR sets, or and nothing would have happened to them. But uh, they were in a state of shock. And when we talk about games which are played in artificial reality or virtual reality, then there is a concept called as super realism, wherein you forget the difference between what is artificial and what is virtual and what is real. So what is artificial and what is real, you cannot distinguish. It becomes so real. So what are the things that happen with you in a virtual world? They are perceived as if they are happening in a real world. Now the question comes up, will you apply real world laws to all those acts or omissions that have got committed in an online setup? We have law for online stalking, but we do not have laws wherein your virtual avatars, if they are getting, let's say, groped or harassed, or imagine there is a virtual character, you are playing it, you yourselves are claustrophobic, your behavior and your actions are, even the virtual characters would reproduce them, because there have been many studies according to which virtual characters behave in a similar way, the way the person is in his real life. And now someone pushes you in a pit or locks you in a room which was not the object of the game, which you had signed in. So volunteer, non-fit, injuria, etc., those defenses cannot come up. You had never given consent for such things, and then something, and you are, it traumatizes you, that incident traumatizes you. Should it not be considered as a real world crime? As of now, we do not have any law for this to penalize, but we need to start thinking about it. Definitely we have laws for online obscenity. If obscenity happens while playing an online game, it can be addressed. Pornography happens, child pornography happens, we can take care of it. To certain extent, our criminal intimidation laws can also be of some help. But if this thing is entirely happening in virtual space, virtual medium, then it would be really difficult to apply our real world laws, real world groping laws, real world rape laws to them. That would require some stretch of imagination that cannot be allowed. But that also does not mean that we cannot should not think of it, and we should not come out with some sort of legislation. That is one. So coming back to the point of online gaming in India nowadays, or day by day, if you see, are being published or are being organized by online gaming intermediaries. These online gaming intermediaries, they fall within the intermediary guidelines of 2023. That this is one. Second, when we talk about intermediaries, online gaming intermediaries, we have to first know and understand what is an intermediary. So an intermediary, as per an intermediary guidelines, is an entity which stores, receives, etc., kind of data on behalf of another person. Okay, so the definition of an intermediary under IT Act is very broad. If you are storing, transmitting, recording data, providing services on behalf of another, then you fall within the ambit of an intermediary. And if I have to quote, for that matter of sake, if I have to quote the definition, an intermediary with respect to any particular electronic record means any person who on behalf of another person receives, stores or transmits that record, or provides any services with respect to that record, and includes telecom service, network service providers, internet service providers, etc. So, this is an intermediary. And if you look at the intermediary law, because same law would be applicable to online gaming intermediaries, and in addition to the law that is applicable to intermediaries, there is certain additional due diligence for online gaming intermediary. Okay, so first we have to understand what is the liability, responsibility of an intermediary. So if you look at the intermediary law in India, it basically consists of two parts. One is your safe harbor, and another is your notice and takedown provisions. Now, what is safe harbor and notice and takedown provisions? So, safe harbor means that the intermediary shall not be held responsible for the content that is posted on their platform. Okay, so what, because these days online games also allow certain kind of interaction, interchange, and allow certain kind of content to be uploaded, modified. So whatever that nature of the content is, for that the intermediary should not be held liable. So safe harbor would be extended to these all online gaming intermediary if their role is limited just. So see, when it comes to intermediaries, an intermediary shall not be held responsible for any third party information, data or communication link made available or hosted if its role is limited to just providing of access to communication system, if it does not initiate transmission, select who receives the transmission, select or modifies the transmission, observes due diligence, observes certain rules and regulations, etc. So here, if you see online gaming intermediaries, uh, their role is more pervasive. They are not very much passive. Of course, if it would be a very and these days the games are such that where they are only hosting of certain information, or only transmitting certain information, only storing certain information. They are very much into it. They are interactive. It's a commercialized activity, and the kind of features which they are offering is does not make them passive player. They are very active. So they are left with nothing but to observe the due diligence and other regulations under intermediary guidelines of 2021. Now, the second part that I had said about an intermediary is that the intermediaries are supposed to follow the orders or instructions or requests rather, made by government agencies, and the intermediary is supposed to expeditiously remove or disable access to the material on the relevant resources which is being used to commit an unlawful act. Okay, so government agencies or courts, if they are letting the intermediary know that certain kinds of activities are happening on your platform, you need to take it down, you need to stop it in an expeditious manner. They need to do it, otherwise it is violation of the law and they shall be held responsible. Now, if we go into the intermediary guidelines, be it a gaming intermediary or a non-gaming intermediary, it says that you have to inform your users that they will not post certain kind of content. That is one. They shall put reasonable efforts that certain problematic type of content is not posted on the gaming platform. Now, what is this problematic type of content? That is another question. Where if the content is in the nature which is harmful to child, if it's a content which belongs to another person and to which the user does not have any right, which is obscene, pornographic, pedophilic, invasive of another's privacy and similar, or it deceives or misleads the addressee about the origin of the message, or knowingly or intentionally communicates any misinformation, then it's something which impersonates other, or it is of the nature which threatens the unity, integrity, defense, security, sovereignty of India, etc., or which contains software virus or computer contaminant designed to destroy or limit. So if the intermediary's job or duty is to just tell its users that please do not post such kind of content, okay, we do. That is one. Second, as per the new amendment, they say that the intermediaries are supposed to take reasonable efforts that such kind of content is not posted. And third, they have to keep on reminding every year their users that please do not post such kind of content. If you are doing so, then it shall be considered that you have taken care of due diligence. Okay, that is one. Now I am discussing certain expectations from any intermediary. It can be a social media intermediary, it can be an online e-commerce portal, it can be an auction site, it can be a search engine, it can be a telecom service provider, it can be a network service provider, any of those. Okay, these are generic expectations from an intermediary, because online gaming also is happening mostly through intermediaries, OGIs they call it. That's why these expectations are from them also. These expectations are from online gaming intermediaries also. Now, another expectation from a specific type of expectation from online gaming is that these online gaming intermediaries should not allow any online game which is not verified as a permissible online game, and which is in the nature of an advertisement or a surrogate advertisement or promotion of an online game that is not permissible online game. Okay, so this is an additional set of due diligence that has been expected from these online gaming intermediaries. There are certain other additional due diligence and there are certain other additional expectations from online gaming intermediaries which we will discuss in due course of time. Now, it is expected from any intermediary, also online gaming intermediary, that they take reasonable measures to secure its computer resource and information contained therein, to follow reasonable security practices and procedures as prescribed under reasonable security practices and procedures and sensitive information rules of 2011. Okay, so these rules which are applicable to body corporates and which take care of data privacy are also applicable to online gaming intermediaries. And data protection part in an online games is taken care of through these rules. We all know that till date Digital Data Protection Act is yet to come into picture. So where do we rely for our personal data privacy? These are the rules on which you will rely upon for your data privacy. So they have these principles of data limitation, purpose limitation, necessity, the whatever those principles of privacy are, like lawfulness, fairness, transparency, There are certain limitations on purposes of collection, processing, and storage of data. So data minimization, integrity and confidentiality, accountability, purpose limitation, lawfulness, fairness, transparency, all those cherished principles of data privacy of users who are playing online games are taken care of through these rules. Now, the next thing in line is that the intermediary rules expect that these intermediaries shall provide information under their control or shall provide assistance to government agency which is lawfully authorized for investigative, protective, cyber security and other reasons. So these intermediaries are supposed to cooperate. They are supposed to give or provide information under their control to the government or provide assistance to the government. Now with other generic type of intermediaries, they are given a time period of 72 hours by which they can inform or provide information which is sought to them by the agency, by the government agency. They have 72 hours. But if it's an online gaming intermediary, they only have 24 hours. So if a government agency is asking an online gaming intermediary to provide certain kind of information or to assist them, now some people are saying assistance means, giving out or providing information will mean giving out their passwords, IDs, chats, the skins that they have bought, the points that they have collected, the things that they have said, all the data that is available with an intermediary has to be provided to the agency if the agency seeks it, if the appropriate government agency seeks it. And what are the grounds under which it can seek? For investigative, protective, cyber security activities for the purpose of verification of identity or prevention, detection, investigation, etc. of offenses. So if these purposes are there and if government agency is seeking information from an online gaming intermediary, an online gaming intermediary has to respond within 24 hours. For others it is 72, but for online gaming it is 24 hours. So this is again a specific type of additional due diligence that is expected from. Now, another type of due diligence which is expected from an online gaming intermediary is that they have to appoint 3 people with them. Okay, if you're a normal intermediary, you may not have to do this. But if you are a significant social media intermediary, while I must say that, okay, fine. If you are a significant social media intermediary, or if you are an online gaming intermediary, then you have to appoint these 3 types of people. What is a significant social media intermediary? You have to have certain amount of subscribers, into millions in case you have, and this figure will keep on changing through government notification. But if your users are into millions, then you are called as significant social media intermediary. But when it comes to online gaming intermediary, there is no prescribed number of users as of date. So the moment you are an online gaming intermediary, I mean your nature is like that, your number of subscriber may not be in millions. Even that will be fine. But you still have to appoint 3 kind of people for grievance redressal. Okay, what are these 3 people? One is you have to appoint a chief compliance officer. Another is you have to appoint a nodal contact person. And the third is you have to appoint a resident grievance officer. So these 3 types of people you will have to appoint the moment you are recognized as an online gaming intermediary. What these new amendments have done is which were moved in 2023 they have further classified online gaming into online games and online real money game. And whenever you are an online real money game, then the kind of responsibility or the kind of liability falls upon you, or the kind of diligence which is expected from you is more. Okay, so there are these permissible online real money games, and there are these non-permissible online real money games. Okay, before going further, I wanted to ask that if you have any doubts till now, please feel free to ask, so that I get to know that we are on the same page and we are not this thing. So you need to have a permissible online permissible game. Uh, it should be to carry out your gaming activities. It should be an online permissible game. Second is, you need to follow additional due diligence if you are an online real money game. Of course, we all know that these online games, they have been taxed 28% under GST, and we are expecting a further detailed framework. We have been looking from various perspectives. We started out discussing from the perspective of privacy. Who would have thought that online games, would raise concerns of sexual harassment, of stress, or of groping. Now, if you see, there is a judgment in India on virtual rape, but let me tell you, that has nothing to do with rape that has happened in virtual space. There was a video that was captured of a person, and it was getting circulated, and and the judge said that every time when it gets circulated, it's very unfortunate that it happens, and there is where the judge uses the word virtual rape, but that had nothing to do with that. Now, we also saw that uh, there are certain tax implications, but and I think some other session would be covering that, and then there is huge this gambling thing also that needs to be taken care of, which also will be there in another session. But mainly online gamings are being conducted by an intermediary, and intermediary is regulated through intermediary guidelines of 2021, which got amended in 2023. Now they have online gaming intermediaries also as an added as a different class of gaming, as a different class of intermediary itself. So there are, if you see the broadly the types of kinds of intermediaries that they have identified in intermediary guidelines, is one is social media intermediaries and another is these gaming intermediaries. The expectations from that of an intermediary in general are similar. Same things are expected from online gaming intermediaries, but online gaming intermediaries are expected more compared to a normal gaming intermediary, or sorry, a normal intermediary. So there is an added expectation of liability from them. And so these are the rules that I was talking about: Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules of 2021. And yeah, this is where they speak of additional grievance redressal mechanism uh, for significant social media intermediaries and online gaming intermediaries. To become a significant social media intermediary, you need to have subscribers in millions. That is how significant social media intermediary is defined. But same is not the requirement for an online gaming intermediary. You might have lesser number of subscribers, but you still have to observe additional due diligence. And what is this additional due diligence? That is, you have to appoint a chief compliance officer who shall be responsible for ensuring the compliance with the acts and rules. You need to appoint a nodal contact person 24 into 7 for the coordination with law enforcement agencies. And the third is a resident grievance officer who shall be responsible for the functions referred in in these regulations. Now, what has happened that as per these intermediary rules, you are supposed to notify the appropriate government agency about the first originator. Now, I know that this notifying of first originator of a particular content would mainly apply to social media intermediaries, because it is social media on which people usually chat. But gaming intermediaries also provide this option of chatting, rather because those who are into too much of gaming, many a times they chat on online games which otherwise they would have chatted on WhatsApp or something like that. Now, if you have to, and if there is a message, there was a content that was circulated in online gaming chat boxes or into social media, and you have to nab the person who was the person who first started sending it, then these are the guidelines. Now, these are being viewed little bit suspiciously, because according to some, they say it is a violation of privacy, and for others it's a matter of security. So if you see the guidelines, it says that this rule is applicable to those whose primary function is of messaging. Okay, so I know it will be a little bit far-fetched to apply this rule to online gaming intermediaries, but then in case of a situation where the online gaming intermediary has assumed the role of messaging, or people are more than gaming, they are kind of messaging each other, they are communicating each other, then I think these rules, or this particular rule, can be applied over there also. It has been found out that certain unlawful and anti-social activities, when terrorists were plotting, and when they used to interact, they used to use these gaming applications to interact with each other, because they knew that other modes of communications are being there is a constant surveillance, there is a chance of interception, it is being monitored, but that might not happen with online games. So they were plotting and they were conspiring, communicating through online games. In that situation, it will become important that from the security perspective, that the government has the information of what is happening over there. Okay. Another aspect of actually there is a specific rule pertaining to there's certain set of rules pertaining to online gaming intermediaries, and I'll just go through them. That an online gaming intermediary who enables access to its users to any permissible online real money game shall display a demonstrable and visible mark of verification by an online gaming self-regulatory body on such permissible online real money game. So this is an additional expectation from these online gaming intermediaries. they who are permitting real money games should display a demonstrable mark and a visible mark of verification by an online gaming self-regulatory body. That is one. Second, they need to inform their users about privacy policy, terms of services, user agreements, etc. And it shall include policy related to withdrawal or refund of the deposit, because what has happened that people have lost sometimes millions into online games because they were not being regulated, and they used to change their policies. People, it's a huge business, so people buy skins, people buy different types of it depends upon the nature of the game. They buy artifacts, they buy weapons, they buy property, artificial property. So, but they were not being regulated. So somewhere they had to be. So there has to be a policy related to withdrawal or refund of the deposit made with the expectation of winnings. Yeah, and then there is expectation of KYC that is to be followed. Certain measures for protection of deposit made by users for such online games. These are expectations from online gaming intermediaries which are into online real money games also. Now, a gaming intermediary, before accepting such kind of deposits from people, they are supposed to identify such user and verify the identity. So this is required for this is required because we have seen impersonation. We know that internet is capable of phishing, internet is capable of anonymization, it is capable of. So the object was also to there was a black market wherein things were getting exchanged and people were continuously changing their identities, accounts were being bought and sold. So to bring some check to it, such kinds of provisions where they are supposed to identify the user, it's and verify the identity, and naturally you will have to rope in the instructions of Reserve Bank of India for that. So that's why the procedure required would be regulated by RBI for the identification and verification of customer at the commencement of an account based relationship. And they have come out with certain circulars that will tell the intermediaries as to how can they have an user on board, how can they get the money deposited, and what are the checks and balances before they allow any user to play an online game. Of course, gaming intermediaries enabling users to access any permissible online real money games shall not itself finance by way of credit or enabling financing to be offered by third party for the purpose of playing such game, because it takes away the character of being a game. Then it becomes, and then we all know, that the financing part, you are not a bank, so you should not be doing it. So the natural corollary that will follow by not allowing these intermediaries is that they are not getting into banking operations, because banks are different and gaming intermediaries are different. That's why they had to categorically say. And certain gaming intermediaries had got into this business of doing this thing, and that's why it had to be stopped. So you need to, if you are into the business of online real money game, then you need to identify yourselves, and you need to fit within the criterias that has been specified. These are those criterias. I need not read them. Naturally, when you are an online real money game, it is expected that you do not involve wagering on any outcome. So it should never assume the character of wagering. In the beginning itself, we discuss that, game of skills are only allowed, game of chance. If you are betting money on it, it becomes a gambling. And unless and until you have a state gambling law, because there are states in India which allow online gambling, you cannot do it. And with those states, they have a list of games, and they have a proper mechanism through which those activities can be regulated. So another significant body for regulating this gaming industry's online gaming self-regulatory body, uh, which against to which you can raise your grievances, and which will, you know can provide you some sort of relief. They can issue certain types of instructions, they for the gaming intermediaries, for the protection of the interest of the users. One more thing is the set of guidelines that we have seen, the set of additional due diligence that we are expecting from an online real money game. If the government thinks fit that, some other entity which is not exactly in the nature of such online real money game should also observe the standards which it is observing, then they can ask to do so. Besides this, there is another aspect of online games, which is IPR violations. And of course, if you are hacking into when you are playing an online game and you have hacked into the game, you have, you know uh, cheat codes which are not permissible. So section 43 of the IT Act is helpful for seeking compensation. If it was done with dishonest and fraudulent intention, section 66 of IT Act becomes applicable, wherein hacking and similar activities are penalized. So if you are hacking into games, and if you are we have seen, or you must have experienced, that certain players, when they hack the game and they take entire situation in their control, right? Their virtual avatars or their characters or their entities can perform those things which are not allowed by the makers of the game. It's an act of hacking. It falls under section 66 of Information Technology Act, and the gaming manufacturer or whosoever is intermediary, they can charge the person under section 66 of IT Act. Now, these gaming intermediaries also have to ensure that whenever they are notified, whenever it comes to their actual knowledge that there is some copyright violated material on their platform, they are supposed to immediately take it down. What is actual knowledge? Actual knowledge means if the aggrieved person has notified them, and after that some court order or some agency have asked them to take it down, that means that they had an actual knowledge that there is some copyright violated content on their platform, which they are supposed to take it down, and which which they should take down. So if you see, one of the landmark cases on this subject is Super Cassettes versus MySpace Industries, and in that case, honorable court had held that an intermediary can only be held liable, this applies to gaming intermediaries also, for copyright infringements when they have an actual knowledge and not merely a constructive or general knowledge of the infringing content on their website. After intermediary acquires actual knowledge of infringement, which may happen when a copyright owner provides or shares information on the infringing URLs to the platform, the intermediary should take steps to remove such infringing content. If they do not do it, then it will be considered that the intermediary has committed a copyright infringement and they shall be held liable. Rest other sections of Copyright Act are applicable to online gamings also. So all those provisions pertaining to fair use, etc., they are all applicable to online games and online gaming intermediaries. So so if an online gaming intermediary is also into online curating of content, that means besides gaming experience, if they are creating a content and giving it to people, then it will be their responsibility that they have to classify that content into different categories. Okay, just like movies or videos that we see on OTT platforms are classified. Now, this is all happening because of intermediary guidelines. Okay, so wherein these intermediary guidelines, they expect that you know, any online curated content, just like Netflix, it's an online curated content. So they categorize their content into different categories. You know, if it's violence, or if it is in the form of something that few might find it problematic, then it serves as a notice to the possible viewers that this content may have nudity or violence or something of that sort, and they language, imitable behavior, depiction of illegal or harmful substances, discrimination, nudity, threat, horror, etc. So, if the gaming intermediary is also curating and creating a content, then they have to describe that content as to in which category if it is falling. If it is so, if it is falling in the categories which I just now told. This is again an additional due diligence which is expected from the online gaming intermediaries.
Thank you so much, Mr. Dr. Anand. We express our appreciation for shedding light on the online gaming landscape, including critical subjects such as gaming intermediaries, IT rules, safe harbor, content regulation, due diligence, and several other topics. Your insights into permissible and non-permissible real money games and gaming taxation provided a comprehensive understanding. Thank you so much for your valuable session, Professor Anand.
Thank you. Thank you. I want to thank the organizers of this course. I want to thank Honorable Vice Chancellor and Honorable Registrar, who is the director of this course, the Center for Sports Law, and the team which has created this program, Aishuman Tripathi, Professor Sajid Sheikh, all those who were involved with the conceptualization of this program. So thank you very much.